We have some recent news on the Johnson & Johnson asbestos lawsuits, but maybe for those people who need to get a little bit caught up, maybe remind us what happened with Johnson & Johnson to kind of get us to this point.
Johnson & Johnson for the last 5 to 7 years has been embroiled in lawsuits all throughout the United States, revolving around their Johnson & Johnson baby powder and other cosmetic powders that they've manufactured historically. There are two cancers that have been alleged, and we think have been proven in courts throughout the United States that exposure to asbestos in talcum powder manufactured by Johnson & Johnson causes ovarian cancer in women and causes mesothelioma in all people. And at one point in the fall of 2021, it's my understanding that there were 38,000 cases of alleging ovarian cancer had been filed throughout the United States, and about 400 lawsuits alleging mesothelioma from exposure to Johnson & Johnson body powders had been filed somewhere in the United States. So, without getting into the weeds too much, because we've talked about this before, Johnson & Johnson essentially formed a subsidiary called LTL Management, and sent all of the talc-based liabilities, all this litigation liabilities, to LTL, and then LTL essentially declared bankruptcy and bankrupted all those liabilities. And it was a complicated transaction that occurred, and essentially, as a part of the United States Bankruptcy Code, Johnson & Johnson, even though it and its subsidiary JJCI, that was responsible for the manufacture of baby powder beginning in the 70s and moving forward, even though those companies weren't bankrupt, they were able to take advantage of the stay that it gets put in place when a company files for bankruptcy. So from October 2021 until April of this year, all lawsuits against Johnson & Johnson arising out of exposure to baby powder or shower to shower or some other body powder, whether it was alleging ovarian cancer or alleging mesothelioma, those cases have been stayed. And so nobody's been able to take a case to trial. Nobody's been able to proceed. And so eventually, in January of this year, the Third Circuit Court of Appeals reversed the bankruptcy court, which denied a motion to dismiss Johnson & Johnson LTL's bankruptcy, and determined that the bankruptcy should have been dismissed. The basis for that determination was that neither LTL nor its parent company, Johnson & Johnson, are in financial distress. That is the single most important factor, whether it's a corporate bankruptcy or an individual bankruptcy, is the debtor, J&J LTL, are they in under financial distress that it could not operate its company without the protection of the United States bankruptcy laws.
Yeah, so why don't you give us that news then? I know that something just happened just last week in terms of the case. So what recently happened?
So, following Johnson & Johnson, or excuse me, following the Third Circuit's decision that the bankruptcy should have been dismissed, Johnson & Johnson and LTL still have some rights in the Third Circuit, and they filed something called a petition for rehearing en banc. Typically speaking, when a appellate court in the federal system hears an appeal from a lower court, three judges listen to that appeal, and it takes a majority 2 to 1 in order for a decision to be rendered. So that's what happened in January. So following that, Johnson & Johnson and LTL sought rehearing en banc, and what that means is every judge that's in the Third Circuit Court of Appeals, and I'm not sure how many there are, but there's probably 15 to 20, that they are asked to also decide whether Johnson & Johnson and LTL's bankruptcy should move forward or whether it should be dismissed. Very rarely are petitions for rehearing en banc granted. And in fact, this petition for rehearing en banc was not granted. It was denied in March, late March. And so on April, I think it was April the 7th, the Third Circuit issued what's called a mandate. And the mandate essentially is a direction to the lower court, which in this case was the bankruptcy court for the District of Delaware. You have to dismiss the case. All appellate rights have been exhausted. You have to dismiss the case, which now effectively means Johnson & Johnson, JJCI are back in the tort system, and people who have been injured as a result of their product can start to litigate their cases again. They can take them to trial. They can get discovery, and engage in the full gauntlet of activities it takes to get a case to trial. Well, that was probably 9:30, 10 o'clock in the morning. And by 3 o'clock that afternoon, LTL filed another bankruptcy petition and sought another stay of all the lawsuits all throughout the United States. It was highly unusual. To be frank, we expected that the first bankruptcy would not be the end of this conflict. We expected that down the road, LTL, Johnson & Johnson, related entities would perhaps refile again. But I didn't expect it to occur the very day that the Third Circuit laid down its mandate.
So now, will you be going after J&J, the parent company now, and not LTL, this other company that J&J set up in order to take over the liability for these cases?
First of all, the court said that we can't really proceed against LTL right now, which is the debtor. Our position has always been all along that Johnson & Johnson and JJCI are the responsible parties for manufacturing this product and for causing people's injury. Now, while the bankruptcy court didn't necessarily say that there was fraud perpetrated on the court, the Third Circuit didn't say that. They did conclude, or the Third Circuit concluded, that this was a bad faith bankruptcy. That because Johnson & Johnson and LTL are not in financial distress, they shouldn't get the benefit of this bankruptcy. So right now, we are able to proceed against the parties that we've always felt were responsible for causing our clients' injuries. LTL, its responsibility is just contractual because Johnson & Johnson gave it the liabilities. LTL didn't exist at any point in time that Johnson & Johnson even manufactured body powders that contain asbestos.
So what does this mean for people now who have lawsuits that are currently filed against J&J, or for new lawsuits that may come up in the near future?
Sure. So it's critically important for people with new lawsuits because they haven't been able to file a lawsuit since October of 2021. As soon as the bankruptcy was filed, all such activity was stayed. So, I mean, they could sue anybody else that they thought might have been responsible, but they could not sue Johnson & Johnson. And obviously you couldn't even get a trial date if you can't file suit. So the good news is no matter when that diagnosis occurred, they can file their lawsuit now against Johnson & Johnson and JJCI just as they could a year and a half ago. So that's good news for new cases or new potential lawsuits. For people that had lawsuits pending against Johnson & Johnson at the time of the original bankruptcy, it's kind of all over the board as to what's going to happen in the immediate future. For example, I have a case that's scheduled for trial in July, and we've had other defendants that are involved in that case, and we've been litigating it for the entire time while J&J has been in bankruptcy, and we have a trial date. And our intention is to try the case against all of them, including Johnson & Johnson in September when the court scheduled the case.